This session, we are going to look at obstacles that may limit an individual citizen from enjoying human rights and also affect the implementation or enforcement of human rights by government agencies and other agencies that may be non-governmental. Now, the impediments to human rights enforcement in Africa generally can be classified into constitutional, social, and political. Those are the main ones. Now, there could be others, but constitutional, social, and political are the main ones. Now, many constitutional provisions on human rights do, instead of galvanizing or energizing human rights goals, they tend to limit and undermine human rights goals. For example, there are very many derogation clauses, which are sometimes, if you look at them, they look very wide, but they could also be ill-defined and sometimes ambiguous or not very clear to the citizens. Now, this constitutes a formidable weakness which can gravely undermine human rights promotion. Also, we do have socioeconomic, sociocultural, economic, and political environment in most of the African countries that is not sufficiently conducive to meaningful human rights regime. In most cases, African governments exhibit regrettable autocratic tendencies and entrench as a culture of impunity, especially by what we normally see our own governments being the first ones to disobey court orders and so on. That becomes a kind of impunity which the government, instead of ensuring it is not there, it is the government itself that brings about this impunity. The result is that citizens do not have the material means to seek legal redress and are often limited in the extent to which they can seek judicial remedy. Now, international human rights has got what we call instruments, and I think we have discussed this in the past, which are essentially what you call multilateral treaties, or treaties signed between countries and also between countries and international organizations such as the UN and others. However, it is most universal in Africa that a country cannot be bound by any agreement to which it has not given consent, either by signing or through ratification or through assenting or through any other means of declaration of intent or intention to be bound by such a treaty. Besides, most treaties are not self-executing, and therefore parties to these treaties are usually enjoined through the local or what you call municipal measures in order to guarantee application of such treaties within their domestic system, so that a treaty will not be binding if, in most cases, if it is not in tandem with the country's own law or constitution for that matter. So most African constitutions contain clauses that imply that human rights treaties entered into by the state cannot become binding until the same have been passed into law by the national assemblies. So even if you have signed, but the National Assembly of Parliament has not legislated and passed these treaties to make them part of the law of the country, then these treaties do not hold. Now, this raises the issue of primacy between international human rights norms and domestic legislation. Which one is primal, or which is the primary, and which one is the secondary? Is it the human rights or the international human rights norms, or is it the domestic law that is legislated in parliament? Now, on the relationship between international human rights instruments and domestic law, which includes the constitution, two schools of thought emerge or have come up. These are the monoism and dualism. Now, in addition to these two, we have another one, a third one, which tends to take a neutral ground, that is the harmonization theory. So we have the three: monism, dualism, and then we have the harmonization theory. The monoism asserts that the international law and municipal law form a part of the universal legal order, serving the needs of the humanity one way or another. But this theory, or rather by this theory, any international treaty, including those concerned with human rights, ratified or assented to by the state, is directly enforceable within the jurisdiction, within that country. Okay? Any treaty, international treaty, including those about human rights, as long as they are ratified or assented to by the state directly, by the state, they become directly enforceable within the state or within the country. On the other hand, dualism holds that international law and the local or the country's, what we call the municipal law, the law of the country, are two distinct legal orders. They are not the same, they are different. And therefore they are actually isolated, and that each may isolate the other, and such ratified treaties are not enforceable until Parliament enacts them into law to incorporate them into the country's law. I hope that is clear. Now, the third theory is the harmonization theory, that holds that man is the focus of both. When you look at the international human rights law and the countries, and that which is legislated within the country by Parliament, the two of them focus on man. Man is the focus of both of these two, because man is a citizen of both the country and also the global citizen. So harmonization theorists contend that both systems are concordant bodies of doctrine. Yes, they are autonomous, but they are harmonious because of their aim, and that is the aim of achieving basic good, and therefore it rejects the presumed conflict between the international law and the national law. There is no, according to this theory, there is no conflict between the two, especially as far as the focus, which in this case is man, who is a citizen of both the global world and also his own or her own country. The view that international instruments, including human rights instruments, should take precedence over domestic legislation is normally submitted to be a better one or a preferred view. That the international one should take precedent is normally seen as a better. In any jurisdiction, even in our own country, we think that the laws that bind us internationally are better than the domestic one, because it's very easy to break or to employ immunity in the locally legislated laws as compared to the international laws, because the big brothers are watching. Now, the subscription of any African to these norms by ratification of the treaties means that the African governments and their judicial agencies are not only legally permitted to derogate from those norms. They are not only legally permitted to derogate from those norms. Accordingly, international human rights norms should be interpreted and enforced in such a manner as to confer primacy on international human rights instruments over the domestic legislation. Domestic legislation, even if when our parliaments, or African parliaments, are enacting laws, they should ensure or try to make sure that the supremacy of the international human rights norms are taken or are given supremacy as versus the national ones. So the various factors that then impede our enjoyment of human rights in most cases, we have several of them. We are going to mention a few and see how and discuss them and see how they impede our enjoyment of human rights. The first one are what I'm calling personal factors, personal individual factors. So that is the first one. Now, these ones affect an individual person in achievement of relative human rights. They are factors that include relatively issues to do with the literacy level of the person, such that your human rights are enjoyed more by the more literate than the more illiterate. Also, poverty is a factor that the poor it's easier to deny a poor person their human rights than the rich people. Lack of enlightenment on human rights, ignorance or lack of knowledge, lack of rational courage to seek for human rights, lack of social consciousness, the nature of social attitude towards freedom and human rights, and the safety of witnesses and witness protection. These factors can constrain the extent to which an individual can participate in government affairs, thus limiting the rational formation and for expression of opinion on critical government actions and decisions. For example, free speech, freedom of speech or free speech, free press has been known to expose corruption, for example. It has also been known to expose abuse of office and other wrongdoings by public servants, state agencies, and political leaders who are publicly exposed by the mass media. The fact that their conduct and character are open to public debate and public scrutiny in the media becomes the greatest check on official misconduct. In general, the freedom of thought, conscience, freedom of assembly and association would have little meaning except in the context of freedom of expression and free press. Therefore, achievement and actualization of human rights can only be enhanced in a democratic environment where majority have the ability to read and write, rather than in a situation of abject poverty or lack of knowledge, or where the levels of ignorance and illiteracy are very high. In other words, freedom of speech and freedom of the press may not have much meaning for all, or for a largely illiterate rural community, completely absorbed in their daily activities and